think the most simplest way to do it for boards is just keep in mind that this is a real public company. You need to do your job properly. You need to take it seriously. You're not there just to show up right before they approve a deal and punch in. You need to be involved. You need to have regular meetings of the board. The board should be fully informed in terms of what's going on. When if there's an LOI, historically there wasn't necessarily a legal requirement for the board to approve it unless unless the SPAC was agreeing to significant exclusivity or other significant liabilities. But quite frankly, we generally recommend that the SPAC boards approve LOIs, if not in advance, certainly shortly thereafter. Meet with the management team and make sure they fully understand it. And a key part of it as well is to really understand the transaction and what's going on in the transaction. From the beginning, understand the business case, understand the diligence that's happening, understand the deal terms, and document all of these meetings that you're having. Have formal meetings. Don't just have the the management CEO call each of the board members individually and tell them what's going on. I can't tell you how many times, we talk to management teams and say, oh, no, we told the directors what's going on. That's nice, but that doesn't help in a lawsuit when they say, show us the board minutes showing that you had meetings and talked about it. So it's important to properly really document the entire process, to document the board's involvement, particularly the independent directors, in the decisions that are being made. Besides everything else, the board also needs to be fully aware of conflict issues. To the extent that their board or any member of management has a significant conflict with the target, it doesn't have to be that significant. Just any stock ownership, any special agreements they have, it should be fully disclosed to the board, and processes should be set up to essentially isolate them from that process and address those conflicts early on. The later you wait to get that done, the less courts will consider it as a proper process, and you expose the board to significant risk by not setting up the processes early on.